So under section 5 they have said about resumption and restitution of granted lands. So the assistant commissioner will come to know that there has been transfer. So how he will be coming to know that there has been a transfer of granted land? It may be by any interested person. The person is interested in that land, he may make an application, or any person may give information in writing to the assistant commissioner, or on suo motu, that is by assistant commissioner himself. The assistant commissioner makes such inquiry as he deems necessary, and he is satisfied that yes, there has been a transfer and that transfer is invalid, that is, it is null and void. Then what he may do? He may give an order to take back the possession of such land. So how he can take back the possession of such land? From the person who has acquired it, by evicting all those persons in possession. So it is going to be done in such manner as may be prescribed, but provided that no such order shall be made except after giving the person affected with such order a reasonable opportunity of being heard. So the person has been staying there, he has acquired it, but because of the order given by the assistant commissioner, he has to evict, he has to vacate that land. So he has to be given opportunity of being heard, and or the assistant commissioner may order to restore back such land, that granted land, to the original grantee. If original grantee is not there, then he has to restore back that granted land to his legal heir. Where it is not reasonably practicable sometimes to restore back that land to such grantee or even legal heir, it is not possible to restore back to him, then such land will be deemed to have been vested in the government, and that too free of all encumbrances. So free from all the liabilities. If there is any loan or any liability upon the granted land, so that is not a matter of duty for the government to pay back. So it is free from all encumbrances vested with the state government. And again, what the state government will do with that land? So it may grant such land again to a person belonging to any of the scheduled caste or scheduled tribes in accordance with the rules relating to such grant of land. So again, we have an amendment made in section 5. So it was inserted in 1992. So here what it says, the assistant commissioner may, if he is satisfied that there is a transfer of any granted land and it is valid, okay, it is not null and void, it is valid, let the transfer happen, then he will pass an order accordingly. So for the subsection 2, what it says? It says there can be exceptions. What exception? Like assistant commissioner has given an order, that should be final, but there can be exception to that. What it is? As per section 5A. So under 5A, the deputy commissioner will receive an appeal from the person who is aggrieved by the order of the assistant commissioner. So the aggrieved person is not happy with the orders given by the assistant commissioner. Assistant commissioner might have given order that you have to vacate, take back the possession from that land, and the person has to vacate that land. That order, or the order given by the assistant commissioner in regards to restoring back that land to the original grantee. So there can be any person who will be aggrieved with that order. So he will appeal to the deputy commissioner that I am not happy with the order given by the assistant commissioner, I am appealing this case to the deputy commissioner. So that is an exception, but whatever orders passed under section 5(1) or 1A by the assistant commissioner shall be final, and whatever the orders passed by the assistant commissioner shall not be cautioned in any court of law. Okay, and there shall be no injunction granted by any court in respect of any proceedings taken or about to be taken by the assistant commissioner, because he is having that power to proceed with the case independently. He is having certain powers conferred under this act. Further, subsection 3 of section 5, it is saying about for the purposes of this section, so if any granted land is in possession of any person, okay, that person is not the original grantee, he is not a SCST, or he is not the owner in the sense that land has not been granted to that person, or even it is not he is not a legal heir, then it shall be presumed that such person has acquired that land by a transfer. So such transfer is null and void under the provisions of section 4 of 1. We have studied that earlier. Until the contrary is proved. Who is to prove that? The person who is in possession, who is not the original grantee nor he is a legal heir of that grantee, then he has to prove how he is staying there, what has what right he is staying there. Again further, here this is a section 5A, okay, it has been amended in 1984. So it is about the after the commencement of the Karnataka SCST PTCL Act. So any person who is aggrieved by the orders passed by the assistant commissioner, so it can be in relating to taking possession of land by evicting the person who are staying there after the transfer, evicting them, remove them from the land, taking back the possession of that land, or it can be in relating to order given by assistant commissioner to restore back that land to the original grantee or his legal heir. Then that aggrieved person, what he will do, he will prefer an appeal to the deputy commissioner. So which deputy commissioner? The deputy commissioner having jurisdiction in that area, and he has to prefer an appeal to the deputy commissioner within a period of 3 months. So 3 months from the date on which the order was communicated to him. Assistant commissioner has given an order and that was communicated to him, and from that date, on the date of communication of the order till 3 months, within 3 months he has to prefer an appeal to the deputy commissioner. So but provided that the deputy commissioner may admit even after 3 months if he is satisfied, he is convinced that there was a sufficient cause for not preferring the appeal within that period. Again provided further that the deputy commissioner shall admit that appeal. So the order was passed by the assistant commissioner, but that order of the assistant commissioner was pending, or it was decided in any court through writ petition. So if there was order given on against the order of assistant commissioner in any court through writ petition, and for that order also, against that order there was an appeal preferred in any court, and that appeal is still pending in that court, even then the deputy commissioner can admit such case as a appeal. He may decide that case which is still pending in a court through writ petition, or it has been decided by the court through writ petition. Further, we have section 5A, subsection 1A. Here you need not get confused with section 5 and section 5 1A and section 5A and section 5A of 1A. These are the amendments, insertions made in this act. So what section 5A of 1A says? It says about after the commencement of the Karnataka SC/ST PTCL Amendment Act 1992. So this insertion amendment was made in 1992. So what they are telling here, they are saying This previously the orders given by the assistant commissioner was against the order given stating the transfer is null and void. So all the transfers were invalid anta ಏನು ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ ಅದರ ಮೇಲೆ agreed person ಇದ್ದ. So but this insertion amendment was made if what if the assistant commissioner has given an order that yes the transfer is valid, it is not null and void, it is a valid transfer, granted land ಇದೆ ಅದನ್ನು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದಾರೆ. So there will be some person who will be aggrieved by this order. So he may prefer an appeal to the deputy commissioner stating that the assistant commissioner has given an order that the transfer is valid, but the transfer is of a land which is granted by the government to SC/ST community person. So here again the same provisions will apply. Deputy commissioner will admit the appeal if it is not within 3 months, if he is satisfied or convinced that yes the appellant had sufficient cause for not preferring appeal within that period, provided further that the deputy commissioner shall admit an appeal against that order passed by the assistant commissioner that yes the transfer is valid, it is not null and void, even after there is a writ petition preferred against such order in the court, or if the order has been passed for such writ petition against the order of the assistant commissioner, and against such order in that court for such writ petition there is an appeal preferred. So even the appeal is pending in that court, even then the deputy commissioner will admit the appeal against the order passed by the assistant commissioner. So section 5A of subsection 2, the deputy commissioner shall dispose of appeal in the prescribed manner. So whatever appeals are there, the deputy commissioner shall dispose of the appeal. Whatever cases came to him as an appeal, he will dispose of in the prescribed manner. There are certain manners prescribed for appeals to be disposed by the deputy commissioner. He has to follow that, and the order passed by him shall be final.